committed to the ideals of justice and equality. A central vision guiding Mr. Hansaria's work is that no individual should be denied access to justice due to economic disadvantage, and that everyone must have an equal opportunity to defend their case in a court of law. This commitment has shaped both his professional and public engagements. Mr. Hansaria is also an author of authoritative works such as The Constitution We Adopted and the Juvenile Justice Act, which are widely referred to by practitioners and scholars alike. He has served as the Vice President of the Supreme Court Bar Association and is also closely associated with the Legal Assistance Forum, working towards ensuring equal justice for the poor and underprivileged sections of society. We are privileged to have him here with us, and we look forward to his valuable insight. I request Ayushka Pandey from HNLU Raipur to come on the stage and facilitate Mr. Vijay Hansaria. Thank you, sir. Thank you, sir. Next, I would like to have the honor of introducing to you all Mr. A.S. Nadkarni, who is a former Additional Solicitor General for India and Senior Advocate in Supreme Court of India. Mr. Nadkarni graduated in law in 1986 and subsequently completed his master's degree in law from Bombay. He began his career in Bombay, juniored in the chambers of a retired High Court judge, and in 1991 he returned to Goa, where he established a successful legal practice. In 1999, he was appointed the Advocate General for the state of Goa. At the age of 36, the youngest ever in the country, a constitutional office which he held for almost over 11 and a half years, prior to his appointment at the national level. In 2016, he was appointed the Additional Solicitor General of India, where he was reappointed to the position in 2019. Today, as a senior advocate of the Supreme Court of India, Mr. Nadkarni's career reflects legal excellence, public service, and institutional trust. It's a privilege to have him here today with us. I request Chandramouli Mishra, who is a mentor of Think India from NLU Odisha, to come to the stage and facilitate Mr. A.S. Nadkarni. Give a round of applause for him. Thank you, sir. And finally, I would now like to have the honor to introduce to you our esteemed guest, Mr. Siddharth Dave. Mr. Dave is an alumnus of the National Law School of India, University of Bangalore, from where he graduated in 1997. He began his practice at the Supreme Court under the mentorship of Mr. Kapil Sibal and Mr. Dushyant Dave. Over the years, he has built a...
Good morning, everyone. It's really a pleasure to be here among young students of law and my colleagues, Mr. Nadkarni and Mr. Dave. Thank you, Mr. Dave, for giving me the opportunity to start this session. I'm told that we are here from, first of all, I must thank Think India to start this initiative. It's a 9th symposium, and it's a very important aspect that the nation first is the motto, and leaders of tomorrow is the final aim that we built here. And I see many leaders of tomorrow here. Why tomorrow? You are the leaders of today even, with the Gen Z time. So you are the leaders of tomorrow, we'll follow you. No, don't worry about that. Whatever support you need, we will get it from us, but you lead us. That's the time. Now we are discussing today 4 important judgments of the Supreme Court about that. And we are here to discuss about the first of them, being the judgment regarding the lawyer's privilege. But first of all, I want to know that you all have come from different parts of the country. I'm told from Goa, from Assam, from Sonipat, from different parts of the country. I come from Assam. Whenever you say it from Assam, I say that, well, how many of you are from Assam? Who are there? Oh, that's good. Good number. Bhal lagil. Bhal korisa yat ahi pelai. Delhi tahibo lage. Delhi is the capital. And it's not that, I'm little biased about Assam, but it's not that equally, it's every part of country is mine. That's how it is. How many of you have read these judgments, or especially the today's judgment, present judgment, which we are talking about, this in re suo moto summoning of advocates? Have you read them? There are very few of you. No, you have to come prepared. Here we are not going to give you a lecture. It's a symposium. We have to interact. You have to tell us, you have to ask questions, you have to grill us. Then you get it. And how do you grill us? You have to read those judgments, no? My friends, next time, whenever you go prepared. And that's the mantra. We have to, wherever I go, I say that I have come here to learn from each other. It's not that I'm delivering lectures and then you are hearing it. It has to two-way communication. Communication can be little more from my side, little less from your side, but it has to be from all sides. So do this in future. Wherever you go, please go prepared and read what you are trying to hear it. So that's how you will carry it forward. That's how you will be the leaders for tomorrow. Now, how many of you think that this professional privilege is required? This interaction between the lawyer and the client is to be privileged. And do you think that it is necessary? And how many of you think that it is not necessary? Why should there be privilege? What is the police going to do? He is trying to find out he is investigating a crime. Why should be obstacle in the crime? Why it is so special about it? Are there anyone who are against it? There should be no privilege. You should be always there to argue both sides. So whenever you go, prepare both sides. Suppose Mr. Nadkarni is arguing against me, no, the privilege is not there, not required. Then you must be in Mr. Nadkarni's team also to assist him. Give him points, why it's not required, why it's so special about lawyers. They are part of the society. If they are involved in a crime, they should be part of it. You should prepare that also. Now, that is, start with. Now, what is this exactly is the lawyer's privilege? Why it is required? First, let us go what it is and why it is required. It is a class privilege between lawyer and the client, right? It is not an individual privilege. And there are class privileges. There are, basically, I'll say, why you do need a class privilege? There are 4 important principles. Anything has a reason behind it. Anything has a principle behind it. There are 4 important principles, which we call it Wigmore principle. They are developed. First is the communication between us means the lawyer and the client, originates on the premise that it will be confidential. When you talk to a lawyer, it is presumed that the client thinks that it is confidential as the accused, and that's how I represent him. I don't say I am so and so, I am Mr. So and so. I say I am accused number 1, I am accused number 2, and whatever protection is available to the accused must be available to the lawyer. That is the scheme behind it. That's why the right against self-incrimination. So even if an accused comes to me and say I have committed this crime, I'm not supposed to tell that, because the law is that, and that's a very fair trial. Internationally recognized principle of fair trial. The prosecution has to prove the guilt in accordance with law. Otherwise, the danger is much more. Anyone can be forced to make a confession and then say, all right, you held guilty. Confession, now there are 164 CRPC new provisions are there, that you have to go to the magistrate, he has to satisfy that it is not tortured, etc., etc. That's a different thing. But statement before the police is not admissible. And it's because, similarly, it is very easy to say, all right, you have gone to the lawyer is asked, did he confess to you? Lawyer is made to say that, yes, he said. If he does not say correct thing, then he may be prosecuted because saying falsely. So that is the very principle behind it. Section 132 of the Bharatiya Sakshya Sanghita now, earlier it was 128 perhaps, of the Evidence Act, which says that any communication between the lawyer and the client is privileged. There are only 2 exceptions in relation to the case. It's not that everything we discuss is privileged. In relation to the case, it is privileged. And only there are 2 exceptions to it. One is, it is in furtherance, except furtherance of illegal purpose. If you want to commit further illegal purpose, it is an exception. Second is, crime or fraud is committed since commencement of the engagement. So it is in future. Except this, it is privileged. Now, how did the question came to the Supreme Court? One of our very, very esteemed friend, Datar, was summoned by the ED. Another lawyer from Gujarat was summoned by the police to say, So it was a hue and cry that how can the police or ED summon a lawyer to give evidence about it? We made all of us made arguments on the Supreme Court. And finally, what the Supreme Court said is very important for all of us to know. It is my beginning, so I shouldn't be taking. We are here till about 12:45, right? Another 5 minutes. What did the Supreme Court say? It says three things. One is the communication between the lawyer and the client is privileged. And if the police wants to summon this, there has to be safeguard. There is already a safeguard under section 132 of the Bharatiya Sakshya Sanghita. But how do you enforce that safeguard? See, the police must, while issuing summon, must say that the lawyer comes, that the investigation or the summon is, exceptions are specified in that notice itself. There are two exceptions. When you, any one of you, we are all future lawyers. Some of you are perhaps already practicing lawyers. You must specify that the exception is there and under which exception I am calling you. That is the first safeguard. Second safeguard is he has to take a written permission from a higher authority. In case of ED director, in case of other thing, superintendent of police. He has to take a consent of the superintendent of police in writing, and that superintendent of police must also record his reasons as to I am satisfied that the notice comes under the exception. So these are the safeguards which has been provided by the Supreme Court in that judgment. Second is important is, this is so far as communication between the lawyer and the client is concerned. Second aspect which is little disturbing is regarding documents. The court has said the privilege does not cover the documents. And it says production of documents in the possession of the advocate of client will not be covered by the privilege. And that's little disturbing. We may have to raise it again in subsequent, because the definition of document is in section 2D and it is very wide. It is very wide. And it says, the illustrations is there, which says a document would include an electronic record or email, server, document, computer, laptop, messages, website, locational evidence, voicemail messages, digital device document. So any WhatsApp message is covered by the document, so they can ask for it, and it is not privileged. So there is a gray area about it. If my oral communication between one-to-one is privileged, why not in WhatsApp message? We are in a digital era. So in a digital era, the messages which is communicated or email which is exchanged, as per this definition, document are not there except come. And document includes an email and a WhatsApp message or a voice message also. There is little difficult area. And the third thing is, which is protected, which was troubling us most, is the electronic device. My smartphone, my laptop, my iPad, etc. can also be summoned. But there the Supreme Court has given certain protections which are quite important, which has 3 or 4 protections which has been given. First is, it can be produced only before the court, not before the police. It's very clear that police can summon it, but it can't be produced. The production is before the court. And the court hears the party and the advocate before passing any order, whether it should be opened or not. And the objections has to be decided by a judicial proceedings, by a judicial order. And the confidentiality, because in my email, in my laptop, in my phone, there may be other clients' documents are there. It must, safeguard must be there that other clients' documents or communications are not breached. So it is only relating to that, which can be summoned. So there are summoning can be before the production is before the court. The court hears the parties, hear the objections, passes an order, and thereafter it can be looked into only in respect of those client communication, not everything which is there. So this is the very basic sum and substance of the judgment. We would like that, all right, we will speak for a few minutes, each one of us. You ask us some questions, you raise some queries, but in future, please read those judgments. That's very important. We are here to learn, and learning can only be, you have come from all different parts of the country. It's not a normal classroom which is happening here. You have come from all over the country, spent time, spent money, and generated interest. And Think India is a very respectable organization which is doing this work for this is the 9th symposium, and think can only be when we are equipped to think, and equipped to think on can only be when we are ready to do anything of the sort. So with this, I'm thankful to you and thankful to Think India that they have invited me for this symposium. Thank you.
Thank you very
And of course, it was a contextual thing in what it was said. But for certain, lawyers can never be killed because the history has not supported it.
Sir, for your inspiring words and for sharing your invaluable insights with us. Your guidance will certainly illuminate our paths as we embark on our legal careers. Now I invite Mr. A.S. Natkarni to share his valuable thoughts with us. Please come, sir.
Lawyer has to work like a horse and live like a hermit. I mean, that was the old recognition of the profession. And we all still believe in it and practice it also. Thank you, Think Tank, Think India, for inviting me. And thank you, everyone, for your patient hearing. Thank you.
Thank you very much, sir, for your inspiring words and beautifully explaining the judgment and sharing your valuable insights on this judgment. It will definitely help us in better assessment and evaluation of cases and guide us further as law students. Now, with the utmost respect and admiration, I finally invite Mr. Siddharth Dave to grace us with his valuable insight and address this esteemed gathering. Thank you, sir.
To all the young friends in the audience, some of you may have been surprised why I said Mr. Hansaria should go first. Some will become lawyers who are practicing lawyers. Some of you will be in a corporate world. But always remember that in our profession, seniority plays a big role. And it's not only by the number of years. Seniority has with it years of more experience than you would have when somebody is senior to you. There is no doubt that in court, when we are opposing each other, we are daggers drawn. You'll say something on one side, the response will come. But outside court, you will extend all the courtesies to your seniors, including the courtesy that the senior most shall go first, second, and third. And there is a flip side, which is a positive side. If you ever go out for a meal or coffee with a senior, you as a junior will never pay. It's only the senior who pays. So for that courtesy, you can get a meal, coffee, etc. out of him. Now, be that as it may, much has been said about the judgment and more beautifully explained than I can possibly explain by Mr. Hansaria and my dear friend, Mr. Natkarni, who I must add doesn't live like a hermit. He only works like a horse, but he doesn't live like a hermit at all. But be that as it may, those of you who will come into practice in the courts, long, hard profession, don't see the glamour, don't see so-and-so is the top earner, so-and-so has appeared in this case, he's grabbing the headlines. All that comes later. First 10 years, nothing. You don't exist. Nobody sees you, your senior doesn't see you. 10 years, people start taking you seriously that, all right, you survived 10 years, so that's the first step in the ladder, and you'll be there. 10 to 20, you'll have juniors, and really after 20 years, your life begins as a lawyer. That also depends upon your own personal ambition. So the reason why I started with that, allow your seniors to go first, is don't be in a hurry. All right. Your generation is in a hurry, I'm told, and every generation says this about the other. Even I was told when I joined, don't start from Supreme Court directly, go to the trial court, go to the High Court. All right. Be that as it may. But don't be in a hurry. It's a good profession, very little money, a lot of work, struggles, mental health issues, you will be exhausted, all those things. But how does the judgment, why we are discussing it, to all of you, how will it help, or why should you be in the know of this judgment? And the simple reason is that the judgment applies both ways. If you are a lawyer, it applies to protect you, as Mr. Nadkarni explained. If you are not a lawyer, suppose you've done your law, the 5-year course or 3-year course or whichever course you've done, and said, no, I don't want to practice law. I'm becoming an artist. I'm becoming an engineer. Or not an engineer probably, but something else. I've become a businessman. Then also that applies to you, because then you come into the situation of a client. And the judgment applies in twofold manners, that a lawyer cannot be summoned on behalf of his client to give information that the client has disclosed to him, because the client is protected by the Constitution. By the client, I mean a person who is your client, or you are the client. He's protected from giving a confession to a police. He's protected from disclosing any information that he may have about the commission of an offense. So if you are the client, it would be easy for the police authorities to summon your lawyer and say, look, this person came to you. Did he tell you that he has committed this offense? And you have to answer truthfully, and you say, yes, he did say this to me. Then the protection that the client has goes out of the window, because the police has recorded a sort of an extrajudicial confession that was made to you. Now I'm getting into the technical things, though I don't like to, but you since are lawyers. So they have obviated the protection that is there in the Constitution as far as the client is concerned. The lawyer loses nothing in this, in the first aspect of this. It is the client who is losing his privilege of having disclosed to his lawyer in confidentiality that I have committed an offense, please protect me. Nothing goes off the lawyer. If tomorrow you say that, all right, a lawyer is supposed to disclose this, he'll disclose it. Who's suffering because of this? It's the common person, it's the client, he's suffering because of this, not the lawyer. He has nothing to do with it. The second aspect which Mr. Nadkarni and Mr. Hansaria touched upon is whether you as a lawyer can be implicated as an accused in a particular offense. Now, I don't see the situation as a complete black and white situation, even though reference was made to some black sheeps. And the example of a murder or a theft having already been committed is an easy example to have. What are the difficult examples are, like in today's day and age, where there are matters of complex economic transactions that take place. And these transactions require certain advice to be given by lawyers to the clients in the course of that transaction. Now, nothing has fructified. It is all in the stage of negotiations between the client and the other person who is acting on the advice of a lawyer. You as a lawyer give a particular advice to a client. That client acts upon that advice, and that advice that the client acts upon comes to be an illegal advice. Now, it can be argued that it is lawyer's advice, it can't be legal, or it's in his best judgment interest. Keep that aside for a moment. If the advice is illegal and the client is being prosecuted for an offense, it will be his defense to say that, look, sir, I did nothing wrong. My lawyer told me this, and I'm talking about complicated issues. He says that I didn't know this. I don't have so much of an understanding about this business transaction. Here is a lawyer, my lawyer. He said, I have studied the books of these transactions. I have studied the Contract Act. I have studied the SEBI Act. I have studied these acts. And thereafter, he advised me to act on it. You can't today hold me guilty of this offense because I only acted on the advice of my lawyer. So in that gray situation, which is a very peculiar situation which would arise, how does an enforcement agency supposed to proceed? Now that, unfortunately, as Mr. Nadkarni said, is not clearly addressed. Lawyer cannot be summoned. Lawyer cannot be, if you are summoning, go to the magistrate, you proceed under 482, the old 482, seek for quashing, you give details of what it is. But it can't be so black and white. Numerous transactions today in the economic field today are based on a lawyer's advice. So therefore, a lawyer, which is all of you of tomorrow, when you step into, be very, very careful when you advise your clients in this nature. Somebody coming to you after the commission and says, I have committed the offense, you don't bother about it. Nobody's going to summon you for that. No one. Take it from me. No police officer is going to summon you for that. But when there are these, and many of you will join law firms. In-house counsels do not have that, but protection. But many of you will join law firms. You'll be retainership of law firms. And thereafter, it will be part of your work there to advise clients on many things. And remember, any part of your advice you may think is correct. You may think as a lawyer is correct, but it is incorrect advice. Now, incorrect and illegal are again two separate things. Law would protect an incorrect advice because that is according to your best judgment. Now, there is no right and wrong in this. But if it is an illegal advice, suppose a section says that this transaction cannot be done in this particular manner, you being fully aware of that section, and you are bound to be, because the law presumes that you as a lawyer would still advise the client that he can do it in exactly the same manner which is prohibited in this section. A lawyer can, according to me, be prosecuted for that. It does not absolve him. It does not protect him. He can be prosecuted. He can do during the matter. He can be summoned during the matter. He can be listed as an accused. I don't agree that he has a protection there if the advice that he has tendered is illegal. The illustrations that you'll find in the BNS, and of course the Original Evidence Act, is that is about the threshold when the lawyer steps in. But after the commission, certainly protected, but during the offense, now whether it ultimately leads to an offense or not, and these are all offenses which are economic in nature, which are all relating to transactions. There are nothing, so it is not so something which is, there are crimes in themselves. They are not rape, dacoity, murder, which are abhorrent to the human society. They are not those transactions. They are prohibitions. Basically, economic, like traffic offenses. They are what you may have studied is malleum in se and malleum prohibita. Offenses which are by their very nature are offenses because they are immoral and abhorrent to the human society, and something like a prohibition. You cannot drive on the left side of the road. You cannot drive on the right side of the road. You cannot transact in this particular manner. Nothing. The society doesn't have anything to do with them, but they are prohibited. So if your advice tomorrow, and were you to give this advice, always please remember to write in there, in your advice that you may tender, that this advice, according to me, is in my best judgment that I am giving. The client should exercise all other due diligences, because you can also, in good faith, give a particular advice, which may turn out to be illegal advice. And it so happens, we see prosecution for title searches. Many times, Mr. Nadkarni, Mr. Hansaria are appearing in quashing matters on behalf of lawyers, where the job of a lawyer and also includes title search. The client comes to him, I am interested in purchasing this property. He goes to a lawyer, he says, please check the papers and see whether this property is free of any and all encumbrances. Lawyer goes to a particular registrar's office, checks there, doesn't find it that there are any encumbrances, gives his title search, the prosecution, and then the property transactions take place. Somebody else wakes up after 3 years and said, oh, sir, this was my property. They have colluded together, and the lawyer has given a wrong report, and therefore he is also made an accused person. We have this situation. Anything that relates to any work being done before the commission of a particular offense is concerned, be very careful and exercise all your due diligence. It's one thing that there is a judgment of Supreme Court, one thing to think that you will protect it. There is no protection. You're out there on your own. And that's why in our legal fraternity, why it is important that it's called a fraternity is because, as Mr. Hansaria was saying, that lawyers are all congregated in one place. So suppose tomorrow, God forbid, if I am summoned by it, I can go to Mr. Hansaria, Mr. Nadkarni, I'll tell him that, sir, look at this summon that has come. All right, let's go to the Chief Justice's court. We'll make this mention and this cannot be done. So you have a fraternity. Therefore, you are required to be respectful to your other side. You always call them my learned friend. The court calls you the learned counsel. All these are there and they should stay. But in that, if you have done something wrong, the first persons who will disappear from your side are your best friends in the profession. They will distance themselves in 1 minute and will say sorry, because they have a high ethical standard. They don't expect you to be unethical in any manner. And if you are unethical in your practice, then take it from me, you will have no friends at the bar, nobody to defend you, because we find it absolutely abhorrent that somebody that has low ethical standards. So exercise due diligence, exercise caution, exercise absolute, to read the letter to the T and then give your opinion. These are all things as far as protection for your opinions are going to come. These are not for any other things about whether in the commission of an offense and then you'll be summoned and all. It was then done by Sir James Fitzjames Stephens in 1875 that police in those days could summon a lawyer and say that, all right, you tell me where is the weapon hidden, where is he has confessed. Firstly, no client comes and confesses. I have yet to come across anyone on the criminal side in 30 years or something that anyone says, sir, I have done it, bachalo. This is all for movies. Nobody does that. Nobody comes and confesses. They all come, they say, this is the case, you argue it, and that's the end of it. So summoning a lawyer really doesn't help. But when you as students of today and lawyers of tomorrow do go out, and when you practice extreme care, extreme diligence, and be true and faithful and ethical in the practice of law, not for a quick buck, not for climbing the ladder faster. Nobody has climbed a fast ladder, and whoever's climbed it fast falls down equally fast. So it's a gradual profession. Follow it, but be true to yourself and profession. Judgment has been discussed threadbare. Go home and read it. As Mr. Ansaria said, you ought to have read it. All right, you've not read it. Read it whenever and understand it. Read and reread till, sorry. All right. Yeah, please. The reason why what I saw in the judgment about why they have not included or narrowly excluded the in-house counsel, you can sit, there's no problem, is that you as an in-house counsel may have an interest in your company obtaining by some illegal means some benefit. So you have a personal interest, which a lawyer who's not working in-house does not have, because he's acting only in an advisory capacity. As far as you are drawing a salary from the company, you're working for the company, and in the interest of the it is in the interest of the company that those that the profits or shares of that company increase. So therefore they have limited it. I don't think that distinction was really warranted. Everyone, it should be in a class. I don't know about Mr. Hansaria and Mr. Nadkarni, whether they have a difference of opinion as far as they should all be covered together. But possibly this could be the reason, since you're drawing a salary from being an in-house counsel, your interest in the furtherance of the business of would make you tend or sway towards saying something which would further that profit making of the companies. That is the only reason that I can see about it. I mean, I don't know whether either of you will agree.
The reasoning is not correct, mainly because you are an in-house counsel for about, say, 1 year, 2 years. You lose your character as a lawyer. You remain a lawyer all the time. Maybe you are an in-house counsel. That distinction, I don't agree with the judgment of the Supreme Court, but then that is the judgment today. It may be that tomorrow it is reversed by a larger bench, and we have now either trend of reversing the judgment in a quick succession, and that is not correct, definitely. Mainly because you are advising. When you are advising as a lawyer, also I am working for the interest of the client. So that distinction, I agree with Mr. Deva that the distinction is not is an artificial distinction in the court, in the judgment.
Sir?
So I fully agree with both of you.
That's the best argument to say. You had something? Sorry? Please do. You are free to ask any one of us this thing here. It's an extrajudicial confession, which is admissible. Suppose he was being treated in a fight that he got into where he committed this murder. He went to a hospital and he told the doctor, like, sir, today I was fighting with this person and I stabbed him. He's lying there dead, but I've also received injuries. Treat these injuries. That is a confession to a doctor. Doctor is an extrajudicial confession, and it would be admissible. Similarly, legally it is admissible if it is made to a lawyer, not in the capacity as a lawyer, but capacity of a person, a private person to whom he has disclosed that I have committed that offense. But rarely does it happen, but it would still be admissible. It's not hearsay. It's not barred by hearsay because it is a confession that is made to him. It is made by the person himself. Hearsay is when you hear it from some other person. That if came once removed would make it hearsay. But coming directly from this person said this to me, yes, that person can't step into the witness box. But this extrajudicial, though it is a weak piece of evidence that is there. But anyway, admissible nevertheless. Yes.
Do you have a mic there?
No, I think there's just one mic. You can come up and speak. We are not formal at all that way. Yes.
That is permitted by law. Error of fact is permitted by law, but not the error of law. However, if the error of law is best in my judgment, let's say I'm not aware of the recent judgment that is being decided by the court, and I go on to advise my client that stands in the contravention of law, how would that be absolving a lawyer or an advocate who advises his client on error of law? I mean, how does an advocate absolve himself or herself from that error of law advice?
You require something more than just error to implicate a lawyer, probably a culpable mental state. You give a series of advice in writing to your client to proceed in a manner which is contrary to law. Series of advice, which is contrary, as you're saying, it's incorrect. You are aware, I mean, you are presumed to know that this is prohibited, but still go ahead, do this. I don't know, but I'm not in these share transactions, etc., where these matters arise. They are complicated issues. And there you are supposed to be aware. It may also be that he's not aware of a particular, I mean, if the SEBI manual is this thick, he's not aware of every little bylaws or regulations that are there. But were he to be, and he gives it, that's one part of it. But mostly it does get borne out from the series of communications if the investigating officer goes through that, yes, this person is goading the client to go in a particular manner, which manner is not a manner which is permissible by law, not just incorrectness of law. Yeah.
Is there any test according to you?
No. No, it will depend on the facts of every case. I don't think they can be. And much more than that, then ultimately what has to be shown is your mental or your culpable state, that you did it because you wanted to help the client to go. Because the client will abandon. He will just say that, or he or she, that, look, this is the advice that I got. That is what happened in the case, actually, in what Mr. Nadkarni was referring to, of the summoning of the lawyers.
It has to be something more than error of law. It has to be motivated. See, if you knew that that is the wrong law and you are giving still that advice, error of law can never be. Today we see the judgments are being reversed by the two bench, three judges, three, four, five reverse, seven. See, it does not become a bad law or error of law. Error of law, everybody can commit an error of law. But if you are motivated, there is a motive inside it, then perhaps then you become an accused. It's what is protected, as the lady has asked, is what is protected is anything during the services as an advocate. But otherwise, if you are a motive, then you are a party to the crime. Then you are not giving advice as a lawyer. And as to make you a lawyer and accused, you have to have a motive. Error of law, just like that, nobody can say. The next judgment which you are hearing is Pragya Singh Thakur, where also appeared. Many of us, I appeared, and my learned friend also appeared. There are 5 judges has been reversed by 7 judges. So it does not mean that the 5 judge was wrong or 7 judge was correct, and tomorrow it may be reversed. So mere error of law, I don't think that you can be hauled up for anything of that sort.
Anything else?
Welcome to Dignitary. My name is Sarthak, and sir, I just want to request your opinion on this. Sir, do you think that lawyers should be summoned when the matter pertains to national security? For example, after the attacks of 26/11, even Akbar Kasab was granted a lawyer, and if the agencies could have summoned that particular lawyer, then he might have revealed some information about future Islamic actions that could be executed, such terrorist attacks, and we might have known in advance that this particular terrorist act is planned to happen at this particular day, so it could have been avoided.
National security ruse, that is always, this is national security, so, all rules of evidence should go out, procedures should go out, everything. By Kasab, India showed to the world that we have what is known as rule of law, right up to Supreme Court. By Kasab. You don't just pick up somebody and take them to your jurisdiction for their trial. He came to our jurisdiction, he was afforded the trial, full trial, every stage, nothing lacking as far as the trial is concerned. You make one exception for national security, tomorrow they'll say NDPS, third ED will claim, fourth you income tax, fifth you see it. One exception you make in this country, and everyone will start clinging on to it. It's like the person who goes, breaks the queue and starts his own queues. Half of the person in the original queue will go and join there. It's just like that. That exception will go on growing. Everyone will forget the original rule itself. So keep whatever it is, be it national security. I don't think our democracy is so fragile that it is bothered about all these national security issues as far as law, rule of law is concerned. Mr. Nadkarni may have a different opinion on this. National security.
National security should not be.
It cannot be an exception. Otherwise, what
You
is
have
national
this.
security?
See, it depends upon the role of a lawyer. For example, if the national security, the terrorist they want to kill someone. If the terrorists want to
On.
go and kill someone, and if the lawyer tells them, look, don't take 635 or .22, take only 303 or some other gun. That's nothing to do with law. Surely it's a part of the whole thing. But if it tells him some other, tells him some other thing purely on a matter of law, etc., then it's a different matter. I mean, obviously, an advice in law is protected. Advice on the facts of do this way.
And only a very good criminal lawyer can tell you the distinction between .22 and a 303 and a 9 mm.
What happens is we see in the traffic. If there is a congestion, then yes, sorry. If there is a congestion, everybody wants to jump this. And that's what if you give the tool of national security, in every case, national security is involved. They're not like, don't follow the queue at a walk. Everybody is in the just like that. So that is a very weak defense. Perhaps if you allow this to happen, then nothing will survive. As you said, Kasab is given and that's how we are recognized as a country ruled by rule of law. One of our best colleagues defended him for 2 weeks in the Supreme Court. Mr. Raju Ramchandran defended him. Supreme Court wanted him amicus. He is one of the very respected lawyers. And he argued with his all full passion for 2 weeks. That's how we are recognized as one of the countries governed by rule of law.
So just a follow-up question. So do you think that the rule of law precedes national security in Sri Lanka?
Sorry? What did you say?
Rule of law precedes. Rule of law precedes national security.
That's what the Big Four principle. What is more important? Rule of law, national security also, when you say the rule of law, national security is taken into consideration. Why do you say there is a conflict between the two? There can never be conflict between the two. National security, when you decide about the rule of law, there is a national security involved. The judges will see that there is a national security involved. They will see that, lawyers will see that there is a national security. Rule of law precedes definitely the rule of law, and it subsumes in the national security, subsumes in the rule of law. Even if there's a cold-blooded militant, he can't be shot. You have to try him. Ajmal Kasab, he was a terrorist, surely a threat to the national security. Police fought him, police threatened him. He was not shot dead there and there. Any other country that would have happened, but in India it did not happen. He was given a fair trial. He was given good treatment in the jail. Food was given to him. He was treated like a VIP. So rule of law precedes national security.
All right. Thank you.
I think you will like to meeting when you become Thank you very much. We had a nice audience. Those who do not have met the judgment, but then you know the judgment. It's good that you know the judgment. Next time, take my advice that you must learn.